So two cases challenging the ATF's bump stock ban and the ATF's authority to regulate similar items have been distributed to the Supreme Court for conference in just 2 weeks. So let's talk about this. But real quick before we jump into this video, if you believe that the ATF needs to be abolished, go ahead and hit that like button and subscribe. So like I said in the intro, two cases challenging the ATF's interpretation of bump stocks as actual machine guns are up for Supreme Court conference and consideration in just 2 weeks. The cases we'll be talking about in this video are Apashian v. Garland and GOA v. Garland. These two cases were carried over from the Supreme Court's last term, and now they are two major Second Amendment cases that the Supreme Court has on their docket for next term and now have distributed for conference and for consideration, and we will see if they are going to try to take these up and issue, once again, two more landmark Supreme Court decisions. These two cases challenge the ATF's ability to arbitrarily change regulatory definitions in a way that's more akin to them creating legislation on their own. These two cases, if taken up by the Supreme Court, have the potential to stop current and future Second Amendment violations by the ATF, which we all know that they have been very active in. They have been going after various things, not just bump stocks. They've been going after frames and receivers. They plan to go after pistol braces. They've gone after various triggers, homemade suppressors, all kinds of items. And so these two cases challenge the ATF's ability to do those types of actions. Now, some quick background on these two cases and how this whole issue arose and what's being challenged in these two cases. For many years, the ATF had correctly concluded that the NFA and GCA's definition of the term machine gun does not include devices like bump stocks. However, after the incident in Las Vegas, the ATF, after being ordered by then President Trump, decided to arbitrarily change the regulatory definition of the term machine gun so that bump stocks as items would be considered to actually be machine guns within their own right. The new rule took effect in March of 2019, and therefore under federal law, owners were required to either destroy the items, to destroy those devices, or to surrender them over to the ATF. This change in definition made possessors of bump stocks subject to punishment of 10 years in prison and or a fine of over $250,000 if they failed to destroy or to surrender those bump stocks. In the Apashian case, Mr. Apashian purchased a slide fire bump stock before the ATF's final rule on bump stocks actually took place. In response to his lawsuit, the Biden administration also filed a brief to the Supreme Court, arguing that the ATF has appropriately interpreted the term machine gun to actually encompass devices like bump stocks. The three main arguments that the Biden administration made in their brief was that the plaintiffs here, the petitioners here, have failed to show a likelihood of success on the merits, and that there is no division in authority warranting the Supreme Court's review of this issue. And they also argued that Chevron deference does not need to be reviewed by the Supreme Court in this context. If you aren't aware what Chevron deference refers to, Chevron deference is a term coined after a landmark case referring to the doctrine of judicial deference given to administrative actions. Generally, for an agency like the ATF to be given Chevron deference, the agency's interpretation of an ambiguous statute or term must be rational or reasonable. So when a statute has ambiguous terms, the agency responsible for enforcing that statute may be able to determine what that term was intended to mean as long as their interpretation is rational or reasonable. In contrast to Chevron deference, the rule of lenity indicates that when dealing with criminal statutory interpretation, a court is required to apply any unclear or ambiguous law in a way that is most favorable to the people, not the enforcement agency like the ATF. The interpretation of the definition of a machine gun does involve criminal penalties, and therefore the argument in this case and other cases as well is that the rule of lenity would direct courts to interpret that term in a way that is most favorable to the people, not to what the ATF says. Now, Apashian was originally set to be distributed to the Supreme Court for conference all the way back in December of 2021. However, while we were waiting for that conference to take place, the Sixth Circuit issued a ruling in another bump stock case called the GOA v. Garland case. That is the Gun Owners of America case that they brought against the ATF. These two cases are similar in nature but arose out of different plaintiffs and also occurred in different circuit courts. The Sixth Circuit en banc panel, in reviewing the GOA case, was unable to reach a majority opinion and instead issued a rare 8-8 deadlocked ruling. This deadlocked ruling in the Sixth Circuit resulted in no precedential appeal court decision, and by default, the result of that was that the lower court's ruling, which prior was in favor of the ATF, had to be affirmed by that circuit court ruling. Now, after that Sixth Circuit ruling, which was deadlocked, the Apashian case, which was at the Supreme Court level, was then removed from conference and has kind of been in limbo ever since. And the theory was that the Supreme Court simply was going to put the Apashian case on hold, kind of put it in limbo until the GOA case was able to work its way all the way up to Supreme Court and for them to kind of be at the same level. And the theory was that the Supreme Court wanted to actually take these two cases up at the same time because they are very similar in nature. They deal with the same issue, the same kind of ATF regulatory authority, bump stocks as well, but it just is different plaintiffs in different circuit courts. The last Supreme Court term, we received a ton of landmark Supreme Court decisions, not just in the Second Amendment context. Of course, we got that Bruen decision, which was really important and was huge for the Second Amendment and Second Amendment litigation going forward. Then you also had the West Virginia v. EPA case, which dealt directly on Chevron deference, the major question doctrine, and the type of kind of regulatory authority that an agency has outside of the scope of what a statute expressly states. Now, although the West Virginia v. EPA case dealt specifically with the EPA as a regulatory agency, that case has broader implications and broader impacts. Really, that case was about what authority do executive agencies have beyond those that are expressly delegated to them by Congress in a statute. In reaching their decision, the Supreme Court, in reviewing that case, said the case involved the major question doctrine. Under the major question doctrine, the Supreme Court declared that if an agency seeks to decide an issue of major national significance, its actions must be supported by clear statutory authorization. Now, let me explain why the use of the major question doctrine is very important also for the Second Amendment context. Currently, the ATF has engaged in various actions, claiming that under the vague statutory language of the NFA and GCA, they have the power under Chevron to make whatever rules they want. This includes their actions banning bump stocks, their new rules against frames and receivers, their new pistol brace rule, which is set to take place in December. Then they have their attacks against rare breed triggers and other triggers that are force reset triggers, and then also homemade, made on your own suppressors or self-manufactured suppressors. So the ATF has engaged in a lot of regulatory actions under their own interpretation and their own arbitrary changing of definitions. And so the West Virginia v. EPA case, which established the major question doctrine, really puts a lot of those actions by the ATF at risk. What the Supreme Court indicated in the West Virginia case is that agencies will no longer be afforded broad Chevron deference when their actions have vast economic and political significance. Again, what the ATF is doing also falls into those categories. So in the Supreme Court's last term with the decisions in Bruen and West Virginia, they really set the framework for this type of lawsuit and this type of challenge, and now it's up to the Supreme Court if they want to hear this issue. And the update really is that both Apashian and the GOA case have been set for conference on September 28th, so just in 2 weeks. Out of these cases, you could get a decision by the Supreme Court that really would hit maybe on the constitutionality of the NFA and GCA, maybe what authority the ATF has to regulate these types of items and other items as well under those statutes, as well as maybe a decision which could drastically rein in the ATF as a law enforcement agency and maybe what they can do in the future. But hopefully we will know really soon, in just a couple of weeks, what the Supreme Court decides they want to do. After a conference is held, usually the following week, we get an order from the Supreme Court indicating what they decided to do after that conference. So once they take it up for conference, we should know fairly soon whether or not they're going to grant cert in that case, in that issue, or whether or not they're going to kick it down the road or just simply deny cert. So these are cases we'll definitely be keeping our eyes on going into these next couple of weeks. If you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, like this video and like support the channel. One of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So again, thank you so much for all of your support. And as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.